Rafa Beneshu, Susan Menge, Jujilani Chizumila Chafika Ben Saula, Stella Anukam, Dumisa Zebeza Madibo Sako, and the registrar. In accordance with Article 28 sub 7 of the protocol and Rule 70 of the rules, the dissenting opinions of Justice Rafa Benashur and Justice Ben Kyoko are appended to this ruling. This is done at Dar es Salaam this second day of December in the year 2021 in English and French, both the French and English texts being equal authoritative. This is the decision of the court.
Thank you, Madam President. The bench will be reconstituted for the reading of the subsequent matters.
Registrar. I don't have that list of judges. The second ruling of the court is going to be delivered by Justice Mukamulisa.
Thank you, Madam President.
La Cour composée de...
Judge, I just beg your pardon because we are dealing the second case. It's the matter of former Somadex SA employees versus Republic of Mali application number 006 of 2018, which is going to be delivered by Judge Chafika. I beg your pardon. Judge Chafika.
Merci, Madame la Présidente.
Thank you, Madam President.
La Cour composée de Imani.
The court composed of Imani Abu, President, Chikaya, Vice President, Ben Kyoko, Rafa Ben Ashu, Suzanne Menge, Marie-Therese Mukamuliza, Tujilan Chizumila, Shafika Ben Saula, Stella I. Anukam, Dumisa B. Insebesa judges, and Robert Eno registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as a protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the rules, Judge Modibo Sako, a member of the court and a national of Mali, did not hear the application. facts of the matter, subject of the application. In the application, the applicants allege that a production excess was achieved for the period 2000 to 2003 at the Morilla SA gold mine, which produced a total of 83 tons, 216 kilograms per year over 4 years of exploitation between 2000, 2001, 2002, and 2003, instead of the initial forecast of 11 tons per year. According to the applicant, the collective bargaining agreement that they signed with Somadex SA provided for the payment of a performance bonus in the event of production targets were exceeded to the tune of 17 billion CFA francs. According to the applicants, only a total of 350 million CFA francs were paid to the employees in this regard. Somadex has since refused to pay the remainder in complicity with the respondent state and closed its doors for good between 2008 and 2009 without fulfilling its obligations to the former employees. The applicants further allege that as part of the initiatives to improve their working conditions, the union committee gave a strike notice on 21st of June 2005. This notice announced a work stoppage for 6, 7, and 8 July 2005. However, the company's management considered this strike to be illegal on the grounds that the notice period provided for by law, that is 15 days before the commencement of the strike, had not been observed. Somadex SA then sent a notice of dismissal to all employees. Subsequently, on 9 July 2005, Somadex SA dismissed the Alo Traore group and 215 others for gross misconduct after they had abandoned their post. On 31st July 2005, the company decided to terminate the contracts of another 311 employees for abandoning their post. The applicants claimed the termination of employees' contracts was illegal, and they denounced the undignified working and living conditions resulting from the non-payment of their performance bonuses. Despite the employees having obtained a decision in their favor during the arbitration proceedings concluded on 10 February 2004, the applicants further said that on the night of 14 September 2005, 2 buses belonging to Somadex were set on fire in the courtyard of the city's gendarmerie. Subsequently, 32 former employees, including union representatives, were arrested and detained for several weeks without a committal order. The applicants claimed that Somadex accused them of having set 2 buses on fire, as a result of which it terminated the contracts of another 17 employees. Finally, the applicants alleged that the respondent state was complicit in the dissolution of Somadex SA in order to obstruct the filing of new evidence to compel the company to fulfill its obligations in relation to the rights of its former employees. According to the applicants, the company was subsequently restructured and renamed MAS before becoming Gukoto Mining Services GMS. The applicants contend that this was the reason the Sikaso court on 26th of May 2014 dismissed their case on the ground that they lacked standing for former employees, given that there was no contractual link between them and the employees and the renamed company. Rest of the parties, the applicant prayed the court for the following orders: declared that the 32 imprisoned former employees have rights that must be respected, and ordered the respondent state to pay them the sum of 10 million CFA francs as damages for the harm suffered. Ordered the respondent state to pay the sum of 17 billion CFA francs to the former employees as performance bonuses that had not been paid by Somadex. Ordered the respondent state to pay the sum of 6 million CFA francs to each employee as compensation for the losses suffered. Ordered the respondent state to pay the former employee the sum of 3 billion CFA francs as accumulated salaries for the period between July 2005 and December 31st, 2017. Ordered the respondent state to issue a certificate of employment for each former employee. Ordered the respondent state to pay a penalty of 2 million CFA francs per day of delay starting from the judgment date. Starting from the judgment date. Ordered the respondent state to issue ordered the respondent state to pay a penalty of 2 million francs per day, delaying certain from the judgment date. Ordered the respondent state to pay half of the sum listed in the judgment urgently. Ordered the respondent state to pay legal costs. Ordered the respondent state to pay 3 million francs to cover the cost of the case. Ordered the respondent state to pay the round trip transportation to the court. Ordered the respondent state to pay the sum of 7 million CFA francs. For its part, the respondent state praised the court for the following: as a matter of form, declare the application inadmissible on the grounds that it does not meet the admissibility requirements. Has jurisdiction on admissibility, dismisses the objection to the admissibility based on identification of the applicants, upholds the objection to the admissibility of the application on the ground of non-exertion of local remedies, declares the application inadmissible on cause, orders that each party shall bear its own cost. Done in Dar es Salaam, this second day of the month of December 2021 in English and French, the French text being authoritative after being signed by the judges referred to above.
The third decision of the court is on the matter of Yaya versus Republic of Mali. And before application number 001 of 2021,